2 clear days in advance of any proceeding, etc. Ha ha. We also have what's called the Children's Court Act, 1992 piece of legislation. That deals with the composition and the appointment of judicial officers there in the court, composition, etc. So we have QCAT, everyone knows who QCAT are. That was, in this designation, it was formerly the Children's Services Tribunal, and that was a 2000 Act. If you look on, through Oslo, look on the Supreme Court website, you'll see, or look on the Oslo website, I should say, you'll see that there's cases there from QCAT from 2003 through to 2009. So if you're ever appearing at the tribunal at QCAT as it is now, as it was then the Children's Services Tribunal, there's plenty of cases you can have a look at and have an understanding of what's involved and what they usually do. What do they usually do? They usually do things like blue card reviews. We're all familiar with what a blue card is. They also do things like orders for supervision in terms of contact between parents and children, or no contact, or whatever it might be. So they have reviews of those. It's an administrative body that reviews those decisions made by the chief executive in relation to children that are in care. Now, not in any particular order, but the most, to me, and it's my slant on it, is I'm standing on the mic, so it's my take. The most important sections in terms of the Child Protection Act, as to what you would have reference to if you're appearing there, are as follows. The obvious one, section 104, which is the paramount consideration, paramount's the principal type thing. That's just recently changed ever so slightly, and it's changed to say this. I'm just being very careful, Robin, if you don't mind.
Yes, Jane.
Pass it back there. I just want to be very careful to not misquote it as such. This to me is probably the most important legislative amendment that was made last year, and it's this. And we'll have a few laughs or sniggers, I would imagine, but when making a decision under this Act, the Children's Court must state its reasons for the decision. I'm serious. That is a common fault in this jurisdiction, where there are no reasons given, or the superficial reasons, if you like, or lip service is paid to why that decision-making process has been made and why the order has been made or not, as the case might be. And there's no direct reference made to the evidence that's before the court. I come across that regularly. I've just had an appeal, a successful appeal, on behalf of the Department in relation to that very issue. Section 105, we're talking about evidence here. The court's not bound by the rules of evidence. So you think to yourself, well, is that carte blanche? Then you can go in there and you can throw mud and you can see what sticks. To some degree, I would have to say yes. That said, that will not stand alone of itself. So hearsay evidence, etc., will not stand alone of itself, no matter what practitioners think or what is often a constant jibe against that jurisdiction or this jurisdiction, the Children's Court jurisdiction. I don't believe for 1 minute that hearsay evidence of itself carries any significant weight, and neither it should. Now, we know about the 2006 legislative amendments to the Family Court, to the Family Law Act, and about how we don't necessarily, rules of evidence don't necessarily apply there, and the judicial officer has a discretion. It's a little bit more liberal in the Children's Court arena in terms of what evidence you present, but I take Robin's point earlier that it's been maintained by a body of people, judicial officers, that are not necessarily always very aware of the legislation and what the parameters of the legislation are and how they should be dealing with children's court type matters. As far as that's concerned, I just want to take you to something that most people will be blissfully unaware of if practicing that jurisdiction. There's a case, it's a pretty well-known case to regular practitioners, but it's called Dale and Scott, ex parte Dale. It's a 1985 decision in full court of Justices Andrews, Kelly and Shepherdson. And as far as I'm aware, that's still good law and it still applies. And there's a whole series of points within that case which, to me, is part of my Bible when I go to the Children's Court. I don't mind sharing, it's all good to share. But that case in particular throws up a whole series of issues, or sorry, a whole series of points, where Lord Devlin from the English courts is cited with authority by Justice Kelly, who delivers a decision. And he talks about evidence, and he talks about hearsay evidence, and he talks about it not standing alone. So that's one thing, and I'll come back to some other things that are in there. And of course, being the selective lawyer that I am, who all are, I use that when it suits me. In the court, and everyone does that knows and is aware of it. Section 61, types of child protection orders that can be made. Extremely important in terms of Section 61, because to me, it can be bracketed into certain things, for ease of reference or ease of memory. One is injunctions refraining parents from doing certain things, including contact with children, I might add, their own children. Two, can be bracketed into what we call PSOs, supervision orders, where the department has to supervise certain things. Orders granting custody, number three, short-term, long-term custody, short-term guardianship, long-term guardianship, and I'll make a differentiation between those three. And that's to a suitable person. That suitable person could be a member of the family, or it could be otherwise, but those non-members of the family significantly have to be approved by the department, the chief executive, or the obvious one, granting custody to custody, guardianship, or long-term or short-term to the chief executive, his or herself. Okay, to me the section's self-explanatory in terms of the caveats the legislators place on the placement of the children are in care. But importantly, and most recently, the section's been amended. So there's no ambiguity in relation to the court making more than one order under Section 61. Prior to last year, there was such ambiguity. Again, I've argued this successfully both ways prior to the legislative amendment. Depends what suits my purpose at a particular time. Again, it's depended what suited the magistrate at a particular time, and depended on the individual magistrate too as to what argument they would accept. But up to last year, arguably, you couldn't make more than one order under that Section 61. Now, if you think of what I've just said to you, I just want to give you an example. You could have theoretically, you can now, with a legislative amendment, you can have a child back in the care of a parent, but still the department to supervise the same. Now, but that's for a defined period, so the custody is awarded to the parent, but the department are ordered to have some sort of intervention. Is that? But some magistrates were making orders that were of those six sort of definitions that overlapped, but some, not from a practical perspective, could not work, yet the magistrate would still make an order to that effect. Now, I'm going to state an obvious one, it's just be silly, but for the purposes of the exercise, make a short-term order and a long-term order, or make a custody order and a guardianship order. I'm just being blasé about it now, but there were certainly orders made that just were impractical. Now, in terms of the duration of the orders, the child protection orders, Section 62 naturally follows. You can read that, it's self-explanatory as to what it says about the duration of child protection orders. But we're talking about a strict definition there between custody and guardianship. You find custody and guardianship defined in sections 12 and 13 of the Act. Guardianship orders, short-term or long-term, are very controversial by their very nature, because we know it as parental responsibility as such, and it's conferring that parental responsibility on another person that's not necessarily a parent of the child. But realistically, in circumstances such as child protection issues, especially in terms where a child might suffer from a particular ailment or something like that, or a life-threatening ailment, I should say, then it's understandable to some degree that those have to be conferred. So Robin touched on what's called a threshold criteria, and that's the terminology, the accepted terminology to be used in the child protection arena. That too has been redefined under the legislative amendments, not to any great degree, but we've added 3 new subsections to section 59 of the Act, 5.9. But one thing I suppose of some significance is that there's been an amendment that, to the extent that any prior contraventions may be a relevant consideration to the magistrate determining the matter. So we have something like that in family court jurisdiction in terms of your behaviour and your conduct as such, and that is you're accountable, more accountable I should say, in terms of contraventions of the Act, and that cuts both ways. It cuts to, as Chief Executive is equally as responsible as any parent that's there. Important features of section 59. The child has to be a child in need of care and protection. Again, Robin did touch on it to some degree, but the child needs to be, there has to be no parent willing and able, or able and willing as it says, to protect the child from harm. And to get a strict definition of what we're talking about in relation to that 59 threshold criteria, you have to turn back to sections 10 and 11 of the Act, which define those, and it's a full appreciation of the considerations in relation to section 59 there, or definitions. Section 10, get back, and says this, defines who a child is in need of protection. This is really, really important whenever you're arguing your case in the child protection arena. Defines a child in need of protection as a child who has suffered harm, is suffering harm, or is at unacceptable risk of suffering harm. And, notably it is an and, B, sub B, does not have a parent able and willing to protect the child from the harm. So that's really where you're going with any legal argument you want to forward on behalf of your client in that arena as to whether there's a child in need of care and protection. There has to be a case plan developed, and we think to ourselves, what is this alien concept of a case plan? Case plan really is not necessarily as set out in the parameters of a defined case plan that the department produce. So it doesn't need to be set out in that structured format that's spat off a computer and it's really difficult to understand the source. You have to get that clear, and sometimes the department don't always appreciate that. However, there is an appreciation that the case plan is developed has to cater for the child's needs into the future as to how that child's welfare is going to be looked after in the future. So there's no structured format as such. You see how a case plan is defined in a literal sense in the schedule to the legislation, but to me personally it can be written, it can be transcribed on a piece of paper. It doesn't necessarily have to be structured in the format that's suggested. Now it's not wrong, that's format that's been set down in tablets of stone over a period of time through departmental intervention. It's not wrong of itself because it does offer some form of structured format, it's just hard to follow. But I think to me the important aspect to that is that really it's for parents to follow more than anything else. And I always try to relate, when I act for the department, I try to relate to them that whilst we've got to use that structured form, I don't have any issue with it as such. The language that we have that should be used should be something that's easily understandable to parents who effectively have to follow it too. That's the only quibble as such that I have with a structured case plan format is the language that's expressed. Yep.
I just think that isn't the structure of the case plan something that's developed by the department in their child safety manual?
Yes. Yeah, the structured case plan as such, the question for Sue Ellen was, isn't it something that's structured by the department in the child safety manual? Of sorts, that's correct. Ultimately though, I'll take 2 steps back. I don't know if you people in the room have an appreciation of the system as such as to how we get from A to B. A being departmental intervention, B being an application to the court and a case plan that's developed before the court. There's a whole series of pathways and structures that we go through there. Yes, to answer the question very neatly, there is policy within the department as to how it should be structured and how it should be managed and how it should be presented, if that answers your question. But to get from A to B, we have to go through a whole series of legislative and internal departmental policy type review, for want of a better word, in order to get there. That includes, from a legislative perspective, family group meetings and the like, which is very important. You can read that in the legislation. But from a internal policy perspective, that answers your question, yes, it's something that they have to adhere to, and that child safety officers will be brought up in that structured form in terms of presenting their case before the court. I don't see it as wrong, and I'm not being defensive of the department as such. In the absence of something else that's better, my personal approach is, I don't really mind if I'm presenting for a parent, if I'm advocating on behalf of a parent or the separate representative. I don't mind that structure at all. It's a choice of language that I have the issue with, to make sure that it's a bit more adaptable, a bit more flexible, and a bit more understandable to the parents, because that's really what we're trying to achieve. Same as when we compose draft orders for presentation to the court and family court jurisdiction. We all speak in legalese, we all make it extremely complicated and try to outdo and better each other, and try to make sure we don't split our infinitives and whatever it might be. But really what we're trying to achieve, we're trying to, one, get something past the gatekeeper, obviously, something that's understandable and it's sensible, but really something, a working model for parents who effectively have to pick up the pieces and work towards and work to. So sometimes we get a bit too caught up ourselves as to what the content of the case plans or whatever it might be. Yeah.
The contraventions that you mentioned were section 59.
Yep.
Does that also include the failing to comply with goals that have been set out in the case plan?
Yes, I've actually answered that one for a magistrate recently. I was at an appeal for a district court judge who's asked me about it. And my interpretation is that it's all about reasonability at the end of the day. It's the same as what I would apply in the family court or federal magistrates court jurisdiction, explaining that yes, I never achieved that goal or that objective as set out and is designated and agreed to as part of the case plan, and yes, I did consent to it, but for the following reasons. So it's all about what's reasonable in the circumstances. That seemed to be accepted. Anyway, appeal process. Personal favourite of mine, because I seem to be doing a few recently. The appeal process is outlined in Part 4 of the Act. Part 4 deals with sections 117 through to 121. That appellate process I'm going to touch on a wee bit more in just a second. I just want to touch on the actual sections first and then explain something about the appellate process thereafter. You should be aware that there's also a variation stroke revocation section. So, for talking's sake, if there's an order made, let's just say a long-term guardianship order until the child reaches or attains the age of 18 years, it's still possible for a parent, generally, to challenge that decision under Section 65, without going too much, Section 65 of the Act, without going too much into it. There's two considerations that you'd have in relation to that. One is, arguably, you only have one right to challenge that decision under Section 2B. However, under Section 3, you can get leave of the court to challenge it on more than one occasion. So if you challenged it unsuccessfully, 2011, you might go back and challenge it again in 2012. But dare say it's something somewhere along the lines, at least in my interpretation, it is of a Rice and Aspen type thing where there's something significantly changed in between times, because the bar is set higher thereafter when you're back in a second occasion. Again, depending on what magistrate you appeared before. Probably old-fashioned, but it's the truth. There's also a whole series of other things in relation to interim orders provisions in the Act which you'd have regard to when you're appearing in that jurisdiction. And we're talking about what's colloquially known as KOs and KOs. KO being a temporary assessment order, KO being a court assessment order. The easiest way to explain it is these are initiating type applications before that jurisdiction where there's a child at risk or immediate risk, and they have the application has to be made, and it's seeking temporary custody in the Chief Executive until the case can be presented in a proper fashion before the court. Generally, it is a low threshold testing that if you can identify a risk, or if the department can identify a risk to a child, then generally we'll get across that threshold criteria, at least for the predetermined periods that are in the Act under sections 27, etc. Then we go into the other real interim type orders, which are sections 67 and 99. Self-explanatory as to what they are. I won't go into the details of them, but they're just interim type orders. There are adjournment provisions generally in the main. There are strict definitions, and there's actually a definition schedule contained at Schedule 3 of the Act. So if you have any ambiguity or you're not quite sure about anything in particular in relation to that particular piece of legislation, a particular section, look at Schedule 3. I'll offer you some assistance. So that was a joke, but we'll move on. And then again, it's Schedule 2. Schedule 2 deals with what we consider to be aggrieved persons. This is an administrative function from the Chief Executive in terms of an appellate process through QCAT. But they're really what they're called, are reviewable decisions as such. And it gives you strict definitions about what is a reviewable decision and who is an aggrieved person in terms of that. I want to talk, if I may, very briefly about some cases that are really very recent and have changed, to a large extent, changed the scope of the Child Protection Act, as in put strict parameters on the appellate process. I said I'll come back to it. The principles are clearly established. It's clearly established that there's no further appeal from a decision of a children's court. Robin touched on it, from a district court judge. So that's as high as it goes, up to district court judge. That's a district court judge who's obviously determined an appeal from a children's court constituted by a magistrate. I have the relevant authorities, and we're talking about the Department of Communities, Child Safety Services and Cronin and another. These are 2010 decisions that I'm referring to, so it's just last year. And I know them very well because I was in them, I was involved in them. In this case that I'm talking about just now, Justices Chesterman, Atkinson and Justice Lyons, Anne Lyons that is, dismissed an appeal citing the history of child protection full court decisions on that principle. So what they're saying in effect is this: there is no right of appeal and there's no right to seek leave in that jurisdiction. End of. The amount of times prior to that, so prior to 2010, that I've seen applications or appeal brought before that jurisdiction, and it's about suck it and see, and let's see what happens at any given time. I've saw maybe about half a dozen or 8 in my experience or knowledge of, that it was never clearly defined as to whether or not there was any right of appeal to the Supreme Court. It's now clearly defined there's not. End of story. This is not to say that the Supreme Court could or would not intervene in exercising its parents' patri should a situation warrant it. Now, an arguable example has been the second case of that same matter in 2010. The first case of that matter in 2010, where it was Carr and the Department of Child Safety 2010 QCA 27, where the full court did exercise arguably a parents' patri type approach to it, but it essentially said we're going to exercise our inherent jurisdiction here because what's happened in this case is the magistrate has made a decision in favour of the parent. The department appealed that and seek an urgent ex parte application on a Friday night before a district court judge. Now this is, I'm not pointing any fingers or anything, because it's just the case that it happened on a Friday and it happened on a Friday evening. It's just the way that it lay. That district court judge made a determination to return the child back to the care of the department. The child had been in the care of the department. The magistrate overturned that. The district court judge overturned that, if you like. And if we go along with what I've just suggested, there's no right of appeal, end of story, and that's an interim decision until we come to final trial. So the Supreme Court got wind of this, heard the matter, and determined that in circumstances such as this, it's not right, and also arguably we have a right to intervene anyway, because that district court judge has made a decision where the parents have not had any natural justice, the natural justice denied to them because it was an ex-parte appeal, if you like. So what they did say though, contrary to what the parents think they said, what they did say though is the judge made the right decision, but should have allowed the parents a right of redress or recourse thereafter. So in the circumstances at face value, prima facie, on the evidence, it was the right decision. However, the parents should have had that right to come back before the district court and say, well, hold on a minute here, we want to tell you something different, because that was an ex parte application, ex parte appeal. Okay. I would suggest, even though there's appearance can't try and inherent jurisdiction there, the reality is you'd be very careful in bringing any application in that jurisdiction. I've advised that 3 people already, or 3 instructors who contacted me not to bring applications unless they're absolutely sure of the situation. And just because they think they might have a go at it, having a go at it is out the window from 2010. You don't just go and suck it and see anymore. And that's clearly expressed if you read the judgments, the 2010 judgments are referred to. It's clearly expressed in there. We don't want to see you across here unless you've got a right to be here. I'll tell you 2 other quick things. Most notable recent judgments in the Children's Court sitting in this appellant jurisdiction, I'm talking about district court judges here, are as follows. The Department of Communities in Edwards and others, 2011 decision, it's unreported. A copy has been provided to CPAC, so it'll be on the State Court website hopefully shortly. But the essence of this has been, it's been a regular practice in regional courts, and we're talking about far out, that magistrates will make final child protection orders in which the Chief Executive was ordered to do certain things to ensure that the child whom they have custody of resides at a certain location, meaning that the magistrate makes a final decision in relation to custody or guardianship, but also orders the department to do other things. There's no legislative requirement or power for a magistrate to do that. It's ultra vires, it was argued as such, the appeal was upheld, and it's set a precedent now. Magistrates just simply, end of story, won't be making any decisions in terms of contact, etc., post final orders. That's it, end of story. Last thing is the Department of Communities in a Sherwood decision, which is an temporary decision handed down 5th October, and it's in relation to apprehension of bias in that jurisdiction. And you should all perhaps seek a copy of that unreported decision and the written reasons for judgments, which we're just waiting on. Speaking exclusively in relation to the Child Protection Act and the Children's Court Queensland, I would suggest that there's been a recent tightening in relation to the powers of the presiding Children's Court judicial officers, removing some of the ambiguity that's there and the vagueness of the legislation, but problems still very much remain. I could drive an articulated lorry through any particular section in that Act that I've already referred you to. There is a distinct disparity in relation to the funding between the Commonwealth and State, in my humble estimation, in relation to these jurisdictions. The most cynical of us might think that, in the main, the child protection jurisdiction deals with the more socially and economically disadvantaged members of our community, and I find it absolutely deplorable for what it's worth. The result of this, in my estimation, is we've got lower classes that are discriminated against in every way, often without representation. We've got complex and sensitive matters that are dealt with in lower courts. We've got a false economy in relation to the public purse, where nothing's ever sorted. It permeates throughout these children's lives, where, including into their adulthood, and we've all read those horror stories in relation to the same. There seems to be a one-size-fits-all type legislation that never does and cannot address particular case needs. And there's real divide between child protection and family law in general, and to some degree at least a distrust between the two. It seems inconceivable that in a society that prides itself on a multicultural philosophy that we have this. Arguably, the answer might be a more holistic approach to children's welfare, and this delineation between child protection issues and other family law type welfare issues and even youth justice, to me, seems absolutely absurd. Last thing I'll say is this: just like what Robin suggested, there is a Children's Act in Scotland as well. I'm not suggesting Scotland's the be all and know all, because why am I here? But but there's a Children's Act in England in 1989. Scotland followed suit and made a Children's Act, or enacted a Children's Act in 1995. basically making England and Wales's Act a lot better. But
You missed that, didn't you?
No, I'm just
but
mentioning.
in essence, it engages a holistic approach to children's welfare issues, whether that be juvenile justice, family welfare issues, child protection issues, etc. Because I don't know how there can be such a delineation. Thank you very much.
Guys, we've run over a little time. I'm just going to summarise if I can. Firstly, thanks to John for that. I think much of what he said would probably confuse a lot of people. No disrespect to John, because it is confusing. No disrespect to John. It is confusing. There are only two options. John and I have discussed this. Others have discussed it. And if there's a third option, we're all ears. There's a first option and there's a last option. I don't call it a second option. It's not good enough. The first option, and it's an ideal, is for child protection matters to be flicked across, just like all other children matters. Look, you're all nodding, we all know the answer. It has to happen. It has to be flicked across to people who are going to take this work as seriously as they take the work they do already. That must happen. The last option, because it's not a second, is this. There needs to be specialists, dedicated, experienced magistrates practicing in the area of child protection. Not magistrates who are master of all, or rather jacks of all, masters of none, but experienced, dedicated, specialist magistrates. The entry level needs to change. It shouldn't just be straight in at the magistrates court level, which is the children's court level. There should be entry level in the district court and the Supreme Court, as there is in England. Funding should be more readily available for litigants. It is heartbreaking when John and I turn up for the department with a fair bit of experience under our belts and we face parents who sometimes can't string a sentence together, let alone look after their children. It is appalling and it makes me wince. The rules, Lisa O'Neill's not with us tonight, I don't think. I haven't seen her. No, she's not. Lisa O'Neill is working on some rules. There need to be rules. The rule at the moment that John mentioned, I'll just pick on that one, Rule 16. 2 days, that's all you get before you get the material. Of course, you do get it in advance, but that's the rule. It's absurd. Some of the most complex cases this country will hear are child protection matters. 2 days. It's absurd. Reporting, John's mentioned that some of the matters are now being reported. They are indeed. They should be. How on earth we can generate some body of jurisprudence without case law is completely and utterly beyond me. The family courts need to understand better the statutory role of the department. I have touched on that. In turn, then, the department needs to understand that when a 91B request is issued from a judicial officer, it's not a request, it's a cry for help, it's a plea for help. It should be answered, even if it involves an attendance by a barrister or a solicitor from the department to say, we have no concerns for the following reasons, or we have concerns and this is them, but at least to turn up. The Act needs to be changed. John touched on guardianship and custody. Guardianship confers parental responsibility, custody doesn't. There are certain provisions with respect to treatment of children where there isn't parental responsibility conferred. The Act needs to change so that guardianship can be conferred on an interim basis so the Chief Executive or others can make serious decisions, not with respect to medical treatment because that's provided in the Act, but with respect to education and religion. I've come across both of those separately in matters I've been involved in where the department is making certain decisions that it should not. It is as simple as that. Entry level needs to be at 3 levels. The appeal there shouldn't be a ceiling at the district court level, as John mentioned. That should be right the way up to the highest court of this land, being the Supreme Court of Queensland. They should have jurisdiction to hear these matters at first instance as well, in the most serious of matters. There should be a provision for transfer of matters up and down, so if it goes in the Supreme Court and the Supreme Court judge says, I don't think so, it can be sent down to a lower level and lower again, or of course up, so that all these cases find their level, no matter where they enter the system. Costs. There is no costs. There are no costs in the children's court. That should change. Why is it that parents turn up, and very often they do turn up under something of a disadvantage because they're not represented, to have the matter adjourned up because the department isn't ready? Now, I'm not here to bag the department, I've already made that very clear, but cost orders should be made available. Seldom, of course, would they be issued against parents, but they can be issued against the department. There is no order for costs, which basically means there doesn't seem to be too much an imperative on any litigant's part to get their act together. Can you imagine appearing in front of someone like Federal Magistrate Jarrett where you haven't complied with one of his rules, let alone rules in the Federal Magistrates Court rules, he will get his cost book out straight away and throw it at you. Good on him too. That's what should happen. Finally, guys, thank you very much for coming. Please join the Child Protection Practitioners Association. It's a worthy body, it's a step forward, and that's all we need to do. Thanks for coming. Thanks for John for speaking. Thanks to everybody. If there are any questions, John will answer them. I'm off.
I'm sorry? I'll tell you what, sorry, I should have mentioned it before. I did a bullet point type paper, and I'm happy to share it with anyone. So ultimately, if you want to give me your email address, I would click it on to anyone, and you can follow that as a template if you like in relation to this, if you're given in this type of jurisdiction. Yeah, no problem whatsoever. Chairman.